Greetings and salutation to Professor Madya Dr. Norziaton. Today our team will be presenting a high-profile case which is the Sabah Watergate scandal, the public prosecutor versus Teo Ching Kong in the High Court in Sabah and Sarawak at KOTA KINABALU. So our team member will be, the first presenter will be myself, which is Gary, and then the second will be Brother Karim, and then after that will be Brother Amir, and then the last presenter will be Brother Faiz. So first and foremost, we will present the background of the case. After that is the chronology of the case, and then we will discuss the act, which is the Anti-Money Laundering Act, AMLA, and then after that we will present the verdict and the charges from the court, and then we will relate the case with the fourth theory and the ethical code, and last but not least the conclusion of the case. Okay, the background of the case is actually from our beloved state, which is the land below the wind, Sabah. They relate to a government department, which is the water department in Sabah, which is Jabatan Air Negeri Sabah, known as JANS, J-A-N-S, JANS. Okay, so they have received numbers of complaints. MACC have received numbers of complaints over the unfair distribution of water development project contracts in the department. So MACC have spent over a year investigating the two suspects who appear to be living in an upper middle class life. So according to the investigation by MACC personnel since 2015, both suspects are actually linked to 38 different companies since 2010, with the department director, who is Awang Talib, is linked to 17 companies owned by his siblings and proxy, while his deputy Teo Ching Kong is actually connected to 21 companies owned by his family members. So almost every water development project in the state were awarded to both suspect linked companies. And the department was also seen did not auditing its infrastructure projects in 2002. A check by a local newspaper, New York Times, on the Auditor General report from 2002 until 2015, found that the department had only been audited 7 times only, with the record only focusing on its non-revenue water management and privatization of supply. So, in this case, we will focusing one of the two suspects, which is Teo Ching Kong, the former Deputy Director of Sabah Water Department, also known as JANS. He was aged 52 in 2018. So actually, there was an allegation against Teo Ching Kong in respect of the Jabatan Air scandal. The investigation revealed that he was appointed as Divisional Water Engineer of KOTA KINABALU since 1988 in 2015. He was promoted to Deputy Director of Sabah State Water, JANS. In 2015, there was an informal meeting between Division Engineer and District Engineer, where Teo sit as the chairperson for the meeting. And he instructed all the division and district engineer to collect 27.5% from initial cost project from all contractors, which were granted with the project as contribution. The 27.5% were fixed by Teo and approved by Pengarah JANS. 10.75% to be given to Teo for him to divide accordingly to officer of JANS, including Pengarah JANS, for 2.4%. And another 16.75% to be divided to division engineers and its staff. The investigation also revealed that failure to abide by the said rule will cause delay to that division in getting funding. In between 2005 and 2016, the project granted by JANS of KOTA KINABALU were amounted to almost 1.1 billion ringgit Malaysia, and out of that amount, the respondent Teo received an amount of 211,000 after 10.7 ringgit Malaysia after 10.75% deducted for JANS allocation. So this is the chronology of the case. So we have spoken that in 2015, Teo have an informal meeting with the divisional and district engineers, which they decided to have a 27.5% of the initial costs are divided among them, including the Pengarah JANS. In 2016, MACC raided the office of GENS on October 4th of 2016, where they arrest the department director Awang Tahir Talib and his deputy director, which is Teo Ching Kong. They have confiscated an amount of 114 million worth of asset and 53.7 million in cold cash, which further investigate revealed a money trail leading to Singapore, Australia, and New Zealand. In 13th of October 2016, a former deputy director for the department, Liam Nembang, 64, was arrested to assist in the ongoing investigation. On 19 October, 19 district engineer was arrested in connection with the probe for allegedly taking 30% of the contract value which were awarded to proxy contractors. A total of 2.4 million were also seized from them along with procurement files from 27 locations around the state. In 2017, more than 200 witnesses are expected to give their statement for the trial that began on July 2017. And on December 2017, Teo Ching Kong faces 146 counts of charges for misappropriation involving 32 million ringgit Malaysia. Now, in the December 2017, 13 December, Teo is being charged at the High Court of Sabah and Sarawak under AMLA Hua. The motion was to forfeit respondent asset as listed in the notice of motion pursuant to section 51 subsection 1 of AMLA Hua. The assets are amounting to almost 8 million ringgit Malaysia, which is a total of 65 hectares of land in his name alone over a period of 11 years. In 2018, another charge was given upon Teo at the High Court of Sabah and Sarawak under AMLA Hua. The motion was also to prohibit the respondent from dealing with the properties and bank accounts in Singapore that was owned by Teo. So that's all for me. I pass to the next presenter.
The Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001 is the primary statute governing the anti-money laundering and combating financing terrorism regime in Malaysia. The Act was gazetted as law on 5th July 2001 and came into force on 15 January 2002. The preamble, which serves as the purpose or gist of the Act being gazetted, specifically mentioned that AMLA provides for the offence of money laundering and terrorism financing and the measures to be undertaken for the prevention of money laundering and terrorism financing offences. It also provides for the forfeiture of property involved in or derived from money laundering and terrorism financing offences, as well as terrorist property, proceeds of an unlawful property, and instrumentalities of an offence, and for matters incidental thereto and connected therewith. The Anti-Money Laundering, Anti-Terrorism Financing and Proceeds of Unlawful Activities Act 2001 consists of 9 major parts, namely, Part 1 is the preliminary, Part 2, money laundering offences, Part 3, financial intelligence, Part 4, reporting obligations, Part 5, cross-border movements of cash and barrier negotiable instruments, Part 6, investigation, Part 7, freezing, seizure and forfeiture, Part 8, suppression of terrorism financing offences and freezing, seizure and forfeiture of terrorist property, and Part 9 is miscellaneous. A raid on the Jabatan Air Negeri Sabah JNS office was conducted on 4th October 2016, where Teo Ching Kong, as the Deputy Director of JNS, and Awang Muhammad Tahir Muhammad Talib, who was the Director of JNS at the material time, were arrested. The two were arrested with a large amount of cash and assets, which were also confiscated by the Malaysian Anti-Corruption Commission (MACC). The subsequent investigation by MACC on Teo Chee Kiong had revealed the following. Number 1. There were 65 pieces of land in Sabah belonging to Teo Chee Kiong amounting more than RM8 million. Number 2. Teo Chee Kiong owned 2 units of condominium in Singapore which is valued at Singapore dollar 3.1 million. Number 3. 12 accounts in Singapore banks registered under the name of Teo Chee Kiong and one Madam Ko with a huge amount in US dollars and Australian dollars. Teo Chee Kiong was then investigated by the Malaysian Anti-Corruption Commission under Section 4, Subsection 1, Subsection A and Section 4, Subsection 1, Subsection B of AMLAT Papua 2001. The third element is knowing or has reason to believe that the monies are the proceeds from any unlawful activity or fails to take reasonable steps to ascertain whether or not the property is proceeds from an unlawful activity. In this case, the accused did not deny that he is involved in the said scheme. Whether he initiated the scheme or not, the fact that he did not deny getting involved in the said scheme, for example, getting or collecting percentage from contractors, because the accused had engaged directly and indirectly in the scheme that he knew was unlawful, and the said unlawful activity referred to the predicate offence of Section 4 subsection 1 as per the second schedule, and the monies or land specified are the proceeds of a serious offence. It could be inferred by the failure to provide or show that what family business he was involved with. The accused knows or has reason to believe that the monies are the proceeds from an unlawful activity. Therefore, the monies and other assets, such as lands, are results of proceeds of illegal activities under Section 4 of the said Act.
Assalamualaikum and salam sejahtera. My name is AMIR BAHRIN. Today, I will proceed my presentation with verdict and charges for this case. For your information, this case is divided into two, where the criminal application was made in 2017 and 2018. For 2017, it is regarding forfeiture of assets. Meanwhile, for the year 2018, it is regarding prohibition of dealing of property outside Malaysia. First, we go to case in 2017, where the criminal application was made by SPRM to forfeit respondent assets as listed in the notice of motion pursuant to section 56 sub 1 of AMLA. In this criminal application, it was subdivided into two sub-issues. I will explain the sub-issues later, and for the findings of the application by SPRM, the court was of the view that the property under section 56 sub 1 must be a subject to a forfeiture order where the property seized was under AMLA and that there is no prosecution or conviction for an offence under subsection 4 sub 1 of AMLA. Why there is no prosecution or conviction for an offence to proceed with forfeiture of assets? It is to be noted that the case was still ongoing or on trial, where the forfeiture of assets was made under urgency. The court was of the decision that the conditional forfeiture on all assets as listed in notice of motion dated 4th August 2017 must be allowed. We go to the criminal application sub-issues. Number 1, whether property seized are the subject matter relating to the commission of an offence under subsection 4 sub 1 of the AMLA. The finding is that these properties that were seized were also established as subject matter relating to an offence under subsection 4 sub 1 of AMLA. For sub-issue number 2, whether applicant's application to cause a notice to third parties to be published in the Gazette should be allowed. The finding of the court is that since the monies and other assets are result of proceed of illegal activities under subsection 4 of AMLA, therefore notice to third parties to be published in the Gazette is to be allowed. What is third parties in this case? The third parties in this case is that any relevant parties that have interest in the land as gazette in the notice of motion. For this case, the court was of the verdict that SPRM application to cause a notice to third parties is to be published in Gazette was allowed. Next, Section 61, Subsection 4, Sub 1 of AMLA stated that any person who engage directly or indirectly in a transaction that involves proceed of an unlawful activities or instrumentalities of an offence, B. acquires, receive, possess, disguise, transfer, converts, exchange, carries, dispose, or use proceed of an unlawful activities or instrumentalities of an offence, commits a money laundering, and shall, on conviction, be liable to imprisonment for a term not exceeding 15 years, and shall also be liable to a fine of not less than 5 times the sum or value of the proceeds, or 5 million ringgit whichever is higher. Section 56 sub 1 subject to section 61, where it was stated that in respect of any property seized under this act, there is no prosecution or conviction for an offence under subsection 4 sub 1 or terrorism financing. The public prosecutor may, before the expiration of 12 months from the date of the seizure, or where there is a freezing order, 12 months from the date of the freezing, apply to judge of the High Court for an order of forfeiture. From this section, it is divided into three, where the first one, in this case, the judge was of the view that the property seized was the subject matter or proceeds relating to the unlawful activities. That there is no purchaser in good faith for valuable consideration in respect of the property. Lastly, such application must be made before expiration of 12 months, and this application was made on 4th August 2017, while the seizure was executed on 11 November 2016, which was clearly within the time frame. Moving on to the case decided in the year 2000. As this case is still rooting from the same subsection, under section 61 subsection 4 sub 1 of AMLA, I will proceed to discuss on the section 53, where it is stated that prohibition of dealing with property outside Malaysia, sub 1, where the public prosecutor is satisfied that any properties is A. The subject matter or evidence relating to the commission of an offence under subsection 4 sub 1. B. Terrorist properties. C. The proceeds of unlawful activities. And lastly, whether it is instrumentalist of an offence and such property is held or deposited outside Malaysia, the court shall make an order prohibiting the person by whom the property is held or with whom it is deposited from dealing with the properties. In this case, the judge was of the view that the property seized was the subject matter or proceeds relating to the unlawful activities. The court was of the view that prohibit any dealing by respondent in his account and properties in Singapore. And last one, notice of motion by this court is not considered redundant by ongoing Singapore's investigation in his account. Thank you. I will pass my presentation to my colleague.
Fraud theory and ethical code. Fraud triangle found in this case explain the factor that lead to fraud and other type of unethical behavior in the public sector. Theoretically, the three elements must exist for individual to act unethically. First one, from the fraud triangle, they have incentive or pressure. The second one is opportunity. The third one is rationalization or attitude. For the first one, from the fraud triangle, perpetrator needs incentive or pressure to make mistake. In this case, Teo Ching Kong abused his position as a Sabah Water Department Deputy Director. There may be other factors that can be attributed to lack of transparency in the affair of government administration. For the second one is opportunity. There are definitely opportunities for fraud, and this is often the focus area for internal auditor. No information on internal auditor has been conducted since 2010. This is because of the centralization factor, especially the policymakers or decision makers, who are not directly related to the people. Teo Chin Kong sits as the chairperson for the meeting, and he instructs all division and district engineer to collect 27.5% from the initial cost project from all contractors which were granted with the project as a contribution. This is one example that Teo Chin Kong met the opportunity. The third one is a rationalization or attitude. Operator can often rationalize or justify their action. An example of a non-critical people, easy to lie, admire, and politicize, then embrace to report cheating. Investigation also show that there is a percent of the total project provided by JANS KOTA KINABALU amounting to around 1 billion. Fraud theory and ethical code. The following is a list of incomplete fraud indicator is main red flags that may be relevant to JANS entities. First one is pressure from external party, example political structure, legislation, policy and procedure not applied equally across organizations in the public sector. Is main one of the possible reasons for the transfer of the federal government power at the time of this case. Second one is poor IT system and insufficient IT security. As is well known, the technology network there is less rapid and widespread than the Peninsula Malaysia. The third one is centralized decision making, the threaten to undermine the necessary segregation between procurement and approval. In this case, no segregation power is performed. Teo Chin Kong is the decision maker and hold a high position in JANS. The fourth one, new program or a list of program not yet in place with effective control. For example, the project given to the vendor or subcontractor is in the planning without transparency method, and there is no supervisory body for that. The fifth one, no procedure or punishing fraudulent activity over the long period of time in this place. This is because no actual audit record have been conducted since 2010. And the sixth one, management and officer overriding control on the ground of urgent needs. This happens when the JNS director contact the vendor contractor directly without going through the procurement department. High turnover, dismissal or reassignment of the key personnel, lack of technical expertise for the assigned role, lack of human resource to implement control procedure. Senior manager under intense pressure to meet high target may be recourse to unethical means to achieve the objective. Presence of non-routine transaction, the lack proper approval or not supported by appropriate documentation. Disgruntled employee who are dissatisfied with works, compensation or the other factor. Large volume of related party activities undertaken outside the normal course of operation. For the conclusion, whether application to cause a notice to the party to be published in the Gazette should be allowed. First one, proceed of the unlawful activity under section 56 and 53 of AMLA. And second one, unlawful activity as defined under section 61 subsection 4, 1 and 2 of the Anti-Money Laundering and Anti-Terrorism Financing Act 2001. And third one, allowing the MACC application to cause a third-party notice to be published in the Gazette. This issue of corruption has been critiqued by many Sabahan people as much of the federal government supposedly used to improve water service in the state is instead taken by corrupt officials in the state government. Local NGOs say JANS related project should be cancelled because the project is always subject to controversy, while JOS secretary say that the disclosure has questioned all the project and the contract available, implemented or proposed by the Sabah Water Department. Corruption is also factored in the weakening of the Malaysian ringgit due to the ongoing corruption among state officials, with the public viewing the case as one of the many hidden corruption cases in the country. Finally, Teo Chee Kong, 55 years old, on December 13, claimed trial to 146 charges of money laundering involving amount over 32 million. All charges were under section 56 and section 53 is from unlawful activity as defined under section 61 subsection 4 1 and 2 of Anti-Money Laundering and Anti-Terrorism Financing Act 2001.